received. Any member got delegated authority just in case somebody's dropping out later on? Nope. Any declarations of interest? Nope.
Chair, I'm just declaring my interest as chair of the all-party group on press freedom and media sustainability. It's relevant to the Defamation Bill.
Okay. Thanks, Matthew. No chairperson's business. Draft minutes of proceedings. Draft minutes of the Finance Committee on the 13th of December are at page 8, and the draft minute of the meetings on the 15th of December at page 12. Are we agreed on the 13th of December minutes? Agreed. Agreed on the 15th December minutes? Agreed. Matters arising. No other matters arising. Agreed? Agreed. Thank you.
We'll get Mike.
Thank you, Professor.
That took 2 seconds.
Matthew's gone all Steve Jobs on us. Matthew.
That later to the bank balance.
Mike, Happy New Year to you.
Happy New Year, Chairman.
Welcome to the Finance Committee. Team, we're now at the stage of the Defamation Bill, and we're now receiving oral evidence from the Bill's sponsor on the Defamation Bill. The session will be reported by Hansard. Mike, welcome to the committee. The relevant papers are Clerk's briefing notes at page 22. The Bill sponsor's response is at page 29. Departmental response to committee queries is at page 33. The Defamation Bill table is at page 69. Defamation Bill and the EFM are at page 104. In table items, there are responses from the NUJ and the Shadow Justice Council on the bill. I think we're both in those table papers as well. Mike, welcome back to the Committee for Finance. Would you just like to make a few opening remarks to the committee stage of the Defamation Bill, and also to speak to the correspondence that you have kindly provided, and then we'll get stuck into some questions.
Okay. Well, thank you, Chair, and more broadly, can I thank you, your colleagues, and the committee staff for the time and attention to paid to the bill. I know these are finite and precious commodities, and it is appreciated. I've studied the published evidence since we last met, and as an overarching comment, what strikes me is the breadth and the depth of agreement that something has to be done, that the status quo is not desirable, and that some reform is required. But beyond that, there's quite a divergence of view about what the something is that needs to be done. Now, I've addressed the 12 questions sent to me by the clerk, so I'm not going to insult you by repeating those verbally. I'd rather use the next couple of moments to talk not so much about the content of the bill, but the timing of the bill, because departmental officials have made it patently clear that their strong first preference was that nothing should be done legislatively in this mandate, and that they would be allowed to get on with their scoping, preparation, investigation, whatever they're calling it. And in fact, they went so far as trying to have the second stage debate stopped. And I put on record my gratitude to Mr. Speaker Maskey, who was very forthright in his response to the department that it was none of their business, and they were out of order. To be fair to the department, they have given reasons for doing nothing. They have said the Government of Ireland may be about to reform their laws of defamation, and they seem to put great store by the fact that there was a conference in Dublin towards the end of 2019. The department also point out that Scotland already have done something in terms of their Defamation and Malicious Publications Act. And there is an argument, I accept, that you should wait and see if there are lessons to be learned from these developments. However, there is a counter-argument, which I will give to you in two ways, Chair. One is conceptual, and the other is contextual. And conceptually, I can put it no better than the great Russian writer Ivan Turgenev, who said, if we wait for the moment when everything, absolutely everything is ready, we shall never begin. And I think that's true of defamation because it is an ever-evolving environment. Contextually, the department officials were arguing that there was a risk in taking action. In their letter to you of the 9th of December of 2021, the 11-pager, they talk about the risks of taking action. They say the legislation, and I quote here, might be insufficiently evidence-based. I think that's extraordinary, given the evidence base is Dr. Scott's report commissioned by the Department of Finance. They also suggest the bill might be, quote, unfit for purpose, unquote. But you know that I'm simply replicating the Act as it applies in England and Wales. Now, I've heard people say the 2013 Act is imperfect. I've heard people say it isn't delivering the outcomes as intended. I've heard people say it's obsolescent. But I've never heard anybody until this letter say it's not fit for purpose, that it's bad law. I think these officials have exceeded their brief, quite frankly. And if we're going to talk about risks, if there are risks to action, there are certainly risks to inaction, and I give you two, Chair. There's an ongoing threat that one of the main parties of this devolved settlement are about to collapse by walking away. There is also apparently a threat that even if we get to an election in May, that on the far side, we may not find the room to form the essential partnership in the executive office, which is an essential component of devolution. And we know if we collapse, we can be out for years. And if we're out for years, we're stuck with the current laws, which nearly everybody agrees is not good enough. But may I also put on record another statement on page 1 of the same letter, which I find both outrageous and false. And I quote, "This bill is a private member's bill. The Department has previously outlined its concerns relating to the manner in which the bill was brought forward, where no fresh thinking or further consultation had been undertaken since 2013. For the record, Chair, I started the process in 2013. I secured the services of Guy Black, that's Lord Black of Brentwood, who at the time was the executive editor of the Telegraph Group in London, who came into this very building to launch my consultation with an impassioned and argued plea for reform. I conducted an online consultation. I then paused at the request of the Law Commission. I met the then Chief Executive, Judina Leslie, and Dr. Scott, whom you know, and they asked me to pause to avoid duplication and potential confusion amongst stakeholders, to allow them to do their deep dive consultation, which was the foundation stone of Dr. Scott's report of 2016. After the 3-year hiatus and devolution returned, I then worked with the Bills team, with the Speaker's Office and the Northern Ireland Office to ensure every clause of this bill is competent. So how dare officials make such inaccurate claims to suggest I have done nothing since 2013? I have to say to you, Mr. Chairman, if this letter was not privileged, those comments would be defamatory of my character, and I would be considering taking action against the Department for defamation of character.
Mike, I think sort of reading that, and I was struck when I read those comments, but also was struck by the fact about the amount of work that's gone on and the evidence we've already received in this committee to do this as well. I think I will put to the committee after this is that I will be writing to the department, asking them for clarification on that particular view and ask them if they wish to reconsider their remarks. Because I don't think, bearing in mind the work that has already been put in, and both by yourself and indeed by this committee and the people who have chosen to come and give us evidence as well, that is representative of what has happened. And I think it is inappropriate for the department to make remarks like that, and I want to give them their opportunity to both withdraw those remarks and apologise for the ones they've done that as well. But I will ask that question of the committee on completion if you're giving your evidence. Okay.
I appreciate that, Chair. Just a couple more remarks. Perhaps you'd also ask them if they're now dismissing Dr. Scott's report, which was a consultation which happened after 2013 and did contain fresh thinking, not least his bipartite proposal. But what I'm proposing is we return to being in lockstep on the laws of defamation with England and Wales, which is where we have almost always been. Officials, I think, are overstepping the mark by suggesting that fresh thinking is a more important policy outcome than the one that I am pursuing. However, to finish positively, and without trying to circumvent the debate which we will no doubt have now on the clauses, I want to make a genuine offer to address the genuine concerns of the membership of this committee. And it's consistent with something that Dr. Scott said in his oral evidence to you. And again, I quote, he said, "The proposed bill is sensible as a first step subject to appropriate revision," end quote. Now, it's clear that the opinion of the officials in the department, and maybe others, is that appropriate revision can only happen when we see the developments in the likes of Dublin and Edinburgh. So I would propose an amendment to my bill placing a statutory duty on the Department of Finance to continue the preparatory scoping work officials say they're engaged in, monitoring the workings of this bill and what's happening in other jurisdictions, producing a report with recommendations within, say, 2 years of this bill receiving royal assent.
Okay, thanks very much indeed, Mike. And sort of, I know other members will be speaking as we go through, but there are sort of three issues. The first thing is the committee, I think, and I'm not paraphrasing what the rest of the committee have said, but basically we really understand that there has to be change. There is a real need for a defamation bill. But there are three areas that, as we've been going through the sort of evidence base that have come to the fore, that we are particularly sort of seized on and just want to get some sort of views on as well. And the first one I think is very clearly is on the issue to do with sort of the roles of judges and trial by juries and the importance of that, and how we make sure that that recommendation remains as part of the process. The second one is on the issue of serious harm, and it's trying to get to sort of how we get to the point of where that lies and the sort of the definition of that and how that can be most appropriate. And I think something that has really struck us, and I would like to put on record my particular abhorrence of the atrocious attacks on social media of some of our elected representatives, particularly Diane Dodds and other people as well. I think it is just despicable that we're in a situation where we're not able to hold social media to account. And I think it's quite opposite, because when we're considering this bill when we come through as well, because one of the issues we've had in this discussion is about how we deal with the social media companies and how we deal with that as well, and some of those clauses. So I think from our committee so far, those are sort of the three sort of key areas that I think we have honed in on as we've gone through. And it's fair to say that you've reviewed the evidence and seen the evidence that we have seen as well. It's been such a broad spectrum of evidence that we've had the both left and right hand of arc of evidence, and it's raised quite a few numbers of questions of where we want to be. I'm just going to go just down through a couple of points, and then sort of we'll open up to the rest of the committee to do that as well, Mike. But just in your written statement, you indicated that Clause 11 will not prevent defamation cases being heard by a jury, but will instead merely remove the presumption of a jury trial. And parties can, in this case, still apply for a jury trial. Is it your intention, therefore, by sort of in your statement, therefore, is to bring forward amendments that also give the judge the discretion to have the case heard by a jury?
Yeah, that would be the intent, that it would not be the norm, it would not be the presumption, but it would not be entirely ruled out if a judge thought it was the most appropriate way to handle a specific case.
Okay. And sort of one of the specifics, you said you comment on the suggested amendment in Clause 2 where it talks about truth. In order to include a requirement for pre-trial hearings which would amend the rules of court of judicature in order to require the judge to determine a single meaning for the words complained of. And I think the issue we're trying to get there is when it comes to the description of serious harm and how that process is arrived at.
I'm not quite following you there, Chair.
It goes to the nature of the question around about sort of serious harm and the specifics about it and serious harm. And sort of, and the departments of others argued that the serious harm test in England has led to a shifting but not a reduction in legal costs. Would you accept that Clause 1 serious harm, there is sort of real concerns about how it's created?
I don't, but I do acknowledge that there are those who do, Chair. Could I give you one example of my own experience as the difference between what we have now, which is, would the ordinary man and woman in the street think less of you having heard the statement in question? which seems to me is a different test. So some years ago, when I was a broadcast journalist with Ulster Television, I was reporting on an event, and I mentioned that everybody involved with the event had served time at Her Majesty's pleasure for terrorist offences. And I was wrong. One of the number had not. And when this was pointed out to us, we were extremely concerned, and frankly, we were preparing to offer a substantial out-of-court settlement. As it happened, the individual chose not to pursue it. Now, I think under our current regime, would people think less of this person because of what I had said? Yes, I think that test, that threshold would be met. And if we'd gone to court, we would have been in danger of losing badly. But because he was a spokesman for one of the groups who, to use the language of the day, was close to the thinking of a terrorist organisation, would saying he'd gone to prison have caused him serious harm? I don't think so. So it is a different test.
Okay. Moving on to sort of the intent of Clause 5 when you talk about the operators of websites, and sort of, although the intent is to be helpful to local media outlets that host websites and might struggle to police their content, isn't it the case that this clause could be used by bigger social media players? And you're aware probably there's legislation going through Westminster at the moment, the Online Safety Bill, and look, we have taken action to try and get some oversight of what the Online Safety Bill is likely to do and where it leads to. But I think this goes to probably the crux of one of those sort of the main issues that we have.
Yeah. Well, could I say, first of all, I would like to also formally record my disgust at the Twitter attack on Diane Dodds and her family. I actually looked at the account that they originated the attack that came from and discovered I'd blocked it some time ago. So the owner of the site obviously has form. My intent is not to protect Twitter and Facebook. It is to say, if you are defamed by something that's posted on one of these sites, you have the right to go to the Twitter, Facebook, Belfast Live, whatever it may be, and say, you must identify for me the person who is responsible, the author of those words, and identify it in a way that makes it possible for me to take legal action against them, to sue them for defamation. And if you do not or cannot do that, then we're going to go for you. And I know that the focus, and particularly after the Diane Dodds episode, is on the big global players. I'm also thinking about local organisations, media outlets, such as local papers, the sub-regional weeklies, Belfast Live, who allow for reader comment to reports that they publish. They simply don't have the money and the resource to monitor in live time these comments. So what I'm saying is, if you allow people to post, then you have to take the consequences. And the first consequence is, if it's a defamatory statement or one that the individual thinks is defamatory, you've got to provide them with the information to take legal action. I think that's reasonable. And if you don't do that, then as the secondary publisher, you become liable yourself.
Okay, thanks.
And I think that, that there's a chilling on the freedom of speech, particularly for, our weekly newspapers or our regional papers, because they're finding it very tight at the moment in terms of finances. So to have the resources to properly police and cut out defamatory comment at source is probably an ask too much. So that is the intent of the clause. But I also take the evidence that has come from some of the witnesses that this isn't just something for a regional devolved government like ours, or even the national government at Westminster, but it needs probably a pan-European, if not a global approach.
Okay, thanks. Jim?
There's no doubt you've done us all a service by bringing forward this bill. I think what has subsequently happened reveals just the value of these committees and the scrutiny role, because it has brought up a totally new raft, a whole new raft of information and, about this whole issue. And to be honest, I think where I would like to go to is somewhere between the present situation and your bill. I think because there's so much that I am now not that certain about. What clauses in your bill would you die in the ditch over?
Well, I think I said at the second stage there were no clauses that I would die in a ditch over. But having seen the evidence, and I'm very taken particularly by Professor Andrew Scott, in his written response to you on the 29th of October, I think it's very significant that he has said that the move to judge-only trials has had highly beneficial consequences. And at paragraph 10, he said, the importance of this change, the move to judge-only trials, cannot be overstated. Now, I think probably at second stage I was in mind to say, well, if you really want to dig in on jury trials, I'll go with you. But I think the evidence of Dr. Scott in particular is so strong, and strongly in favour of going for judge-only trials with the serious harm test, which means that everything can be decided at the start of the process. And I think that's why, Chair, the money is now redistributed rather than becoming a huge saving, rather than the cost being spread out over a long trial. If you put it into a serious harm test judge-only trial, then you front load because the judge makes the determination what was the single meaning of those words up front. Whereas currently, with a jury trial, he can only knock something out if the meaning that the claimant is claiming is perverse. So I'm now keener on judge-only than I was when I introduced the bill and on its partner, the serious harm test.
You raised quite validly the whole issue about the instability of this institution. It does tend to face crisis after crisis. And I take your point about what could potentially happen in May, or if that could happen before May, never name in May. If there was guaranteed stability, would you have had a different view about allowing us to come back in the new mandate when the various developments will have occurred? In other words, is there a lot of merit in rushing this through and simply on the basis that we're running out of time, rather than giving it the thought that I think this bill in particular requires a wee bit more mature debate before we go ahead and approve it?
Well, Mr. Wells, the expression rushing it through kind of jars with me, given that I started on the 19th of September 2013, upstairs with Lord Black. I really can't accept that this is a rush.
Yes, but of course circumstances outside your control and anybody's control meant that there was a long hiatus in that process.
Yeah, which I've admitted, yeah.
And, you know, we face bills here which we're happy with, bar a bit of tinkering, or are totally opposed to. Your bill falls into a category that there's considerable merit, but maybe just not yet. And in an ideal world, I would have thought the best way forward here, certainly we've done a lot of scrutiny in this, but is to let the hair sit until things develop, particularly in Scotland, and then come back to it in the new mandate. Now, I take your point, there mightn't be a new mandate to come back to. I accept that. So therefore, I see your difficulty. But our problem is we've just had advice here to say just how tight the deadline is on this. And I would just be a bit worried we're going to rush something through we might regret.
Well, could I answer the question with a question, if you don't mind? I mean, how long do you need? How long do we need to be sure about the impact of Scotland's new Defamation and Malicious Publication Act? How long do we need to know before are Dublin going to do anything? And if they do something, how long after they do it do we have to wait to understand the implications? I mean, their defamation laws date back only to 2009, and already they're talking about reform. So I think if we are to do this act, make this bill an act, we should be thinking about its shelf life in terms of years, not decades, in terms of years. And I am making this offer that if we do this now, we build in a duty on the department to come back within 2 years, say, of royal assent with recommendations.
And that's helpful. I must say that is an important development. But does it not concern you that the main practitioner in defamation in Northern Ireland has come out so stridently against your bill?
Doesn't concern me because he came upstairs on the 19th of September in 2013 and told me I've had these discussions. And there are divergent opinions, as you know from the evidence you've taken. I think there's a great strength in getting back into step with England and Wales, and Dr. Scott actually makes that point in his evidence. Consistency with English law, now arguably a more pressing issue. It will become increasingly inappropriate for Northern Irish judges to rely on English law as a guide to the operation of the common law defences retained in this jurisdiction. And we get so few defamation cases going to law rather than being settled out of court that it's going to take a long time to build up our own discrete case law.
We've had the disgraceful incident that happened a few days ago involving an MLA in this building. How do you feel your bill, if enacted, would make it easier for the lady concerned, quite rightly in my opinion, to frankly get punitive damages against that horrendous message that was put out?
Yeah. Well, what would happen is presumably she would retain an appropriate legal person, such as Mr. Tweed, who would contact and ask for the details. You've got to identify the person who posted that tweet and identify them in a manner that allows you to take legal action against them.
But why would it be easier to do it under your bill than present?
Because it puts a duty, it puts it into law. And I think you've heard evidence, and I think we all know from day-to-day life, anecdotally, that those big global institutions are extremely awkward when it comes to identifying the people who have posted and hold accounts.
Thank you.
But so I would add, I do think it needs legislation, at least at Westminster, and preferably as broadly as possible.
Thanks. Militia?
Fáilte Road, Mike, you're very welcome. Agus Blaine Urfu Marshall Dish Foster, and a very happy New Year to you as well.
And to you.
Mike, just in relation to Clause 1, and I know you've alluded to it in your previous answer there, but the serious harm test, it divides opinion. But now, in your opinion, how essential is Clause 1? How essential is it as part of this bill?
I think it's essential because it goes with Clause 11, which means that it's a non-jury trial. So the judge is able to make a determination as early as possible in the proceedings as to whether the case should go ahead. So at the moment, because there's a jury, the judge has to give the jury their place, and effectively all he can do is say, no, I think the claimant's interpretation of the words is utterly perverse. He or she is kind of making it up, squeezing it in. I'm not going to allow it. But and then your single meaning only gets determined at the end of the trial. So if you allow it up front, then I think you speed everything up. You maybe don't reduce costs as much as you might have wished to do, because there are costs, obviously, in all these processes. But you dispatch the case in a timely and appropriate manner.
So are you saying then that Clause 1 is still essential to this process?
Sorry, I didn't catch that. Are you saying?
How essential is Clause 1 in this bill? Do you think it is essential?
I think it's very important, yes.
Yeah. Well, many of the respondents were also very clear that in practice it won't reduce costs and may not even shift the balance towards freedom of expression, but will certainly block the ordinary citizen from defending their reputation. How do you respond to this, Mike?
Well, I'm not sure that I agree that it does block the ordinary man or woman in the street from taking action. But I would also suggest this to you. I don't think very many ordinary men or women in the street have cause to take action for defamation. I think if you speak to some of the people, and if you've had them in this room giving you evidence, it's people like you and me. It's politicians. It's wealthy people. It's influential people. It's also journalists who take cases for defamation. And I'm really not sure that the ordinary man or woman in the street takes a case, or indeed has cause to take a case that often. And remember, the number of cases in recent years is in and around 3 dozen per annum. So what we're really talking about here is the chill effect of a lawyer sending a letter to a media outlet saying, if you go ahead and publish what you're proposing to publish about my client, we will take you. And that has a huge chilling effect, and I think is much more significant than the potential impact on the ordinary man or woman in the street.
I'm not so sure that politicians, whenever you would include, say, councillors in that particular role as well too, fit that snugly in with the more wealthy. And having listened to a recent sort of comment that was made only yesterday, that even for Mrs. Dodds, whom I thought too was despicable that anyone should be attacking any MLA or any other person in that regards, but that for her even to instigate that kind of legislation, I think it's something like £20,000 would be expected for her to sort of attempt to redress or raise the issue. So it isn't just, as I said, the wealthy. It can in fact apply to anyone. And in some respects, does Article 1 in a way that does that actually remove that defence, or Clause 1 remove that from the individual?
Well, what I would say to you about Clause 1 is I don't think there is any good reason in law or in policy why a claim should be allowed to proceed with all the costs and the resources that entails, if there is no reasonable prospect of establishing serious reputational damage.
And the valuation of that serious reputational damage is made by whom?
By the judge.
By the judge. And is he maybe the best person in the position to make that judgment for the ordinary man on the street?
I would say judges have a very significant degree of experience and training in getting to the truth of matters, yes.
Yeah, okay. Thank you, Mike from Magwood. Thank you for your answers.
Thank you. Jim?
Yeah, afternoon, Mike. You've made a couple of references to the fact that you will be producing amendments. Will we see those before we start our deliberations, which effectively is next week?
Well, I've talked about one amendment, Mr. Allister, and I would need to be liaising, I imagine, with the Bills Office, but it would be an amendment effectively to put a duty on the department to bring forward a review within, I'm saying 2 years. Does that sound reasonable, a reasonable amount of time?
So that's the only amendment you're thinking of?
Well, I think I've had to bring forward an amendment which was pretty technical, because I believe, and I can't explain this except it's a kind of can't see the woods for the trees. I think the bill as constituted currently has us remaining within the European Union.
Yes,
Well,
Clause 9.
That's pretty fundamental, yeah.
So, I mean, it's been through...
I'll second that one for you.
The bill's been through many hands, and it took the committee to point that out, so I'd certainly take that in the chin.
Yeah, listening to you today, you've firmed up in terms of the centrality of Clause 1, the serious harm, which I suspect is the very clause that's causing the most serious harm to your bill. Because at the end of the second stage debate, you did indicate that your bill could live without it. You now seem to be saying to us, no, that's essential. So if Clause 1 was removed, What's the future of this bill?
Well, I think the bill becomes poorer, and I base that and my change in attitude largely on the evidence from Dr. now Professor Scott. Again, that note of the 29th of October last, he says that the test remains desirable.
I must say to you, I thought Professor Scott was the least impressive witness that we had in this, but that's only a personal opinion. I think you've still got the problem of the fundamental denial of the opportunity to pursue defamation by the imposition of serious harm, because you're saying, in effect, that a journalist, a broadcaster, any defendant can tell a lie as long as it's not too big a lie. As long as you don't cause serious harm, then that's okay. That's a fundamental flaw in my book in terms of your bill, and remains so. But you are saying, or are you not, that if that was removed, the bill would still stand, or would you fail to move the final stage, for example, if there was no clause 1?
Oh, I would have to reflect on that issue. But I note you have on several occasions talked about the little lie. You've never made reference to the little error.
Well, take for example what you said to us at the beginning of your evidence. You said that the departmental letter, I think it was back in October, which suggested that you'd been indolent in regard to this matter, that you would, in other circumstances, but for the privilege, be suing them. Do you think you'd cross the serious harm test in doing that?
Probably not. I think I would cross the current test much more easily.
Well, does that not illustrate the point that someone who is injured, defamed, and belittled by something that's said under your bill would just have to grin and bear it?
Well, I think as a politician, we should have thick skins.
Indeed. And speaking of politicians, we're all appalled by the episode involving Diane Dawes. Your bill, in fact, would it not, would give greater protection to Twitter, in that all they would have to do would be identify the miscreant and thereby buy for themselves immunity.
That's certainly not my interpretation. My interpretation of the intent is that it would make it easier for the person who has been abused and defamed to identify the person responsible for those words and to take legal action against them.
But not against the body that platformed it.
Sorry?
Not against the body that platformed it.
Only if the party that platformed it was unwilling or unable to identify the person who was responsible for the words appearing on that account.
Yes, but once they did identify them, they buy themselves immunity under your clause.
And what is your objection to that?
Well, the person they identify may well be a man of straw, and therefore, effectively, there is no remedy for the person complaining, and they cannot proceed against the body of substance, namely Twitter or Facebook, because by identifying the man of straw, they have bought themselves immunity.
Well, anybody can be defamed by a man or woman of straw at any time on any communications medium.
Yes, and isn't that why we've always had the fallback that if the publisher of the libel can still be pursued, never mind the initial libeller, because they publicised it, and they are not, the commercial interest, are not a man of straw, and therefore you always had recourse to an actual remedy against the party that had facilitated and published it. Your bill would remove that facility in circumstances where the man of straw is identified, and therefore the publisher, Twitter or whoever, escapes.
And what would be the effect on, for example, the Belfast Telegraph, Irish News, Newsletter, Belfast Live, if they had to moderate every single comment before it was uploaded, the effect would be enormous chilling of free speech, because they simply don't have the money, the resource, the manpower, the person power to do that.
Don't most of them have insurance for that very purpose?
Well, I've said previously in front of this committee, when I was at Ulster Television, we had insurers, but on every occasion we had a defamation case. The insurers instructed us to settle out of court because they wouldn't cover us for a court case, because the jury could find against us and could give an extraordinary quantum in terms of settlement.
Yes, but the defendant was in the luxurious position of knowing that they had the safety net of insurance. The hapless plaintiff never has that.
The insurance
doesn't have legal aid or anything else.
The insurance was effectively withdrawn.
Yeah, but
so there is no insurance.
In contrast to the plaintiff who has to bring the case at his own cost, at his own risk, with no safety net. When you compare that with the commercial interest of the publisher, the two are totally incomparable. And you want to now create a situation where a person who risks their own money in bringing a case, say, against something that's been tweeted, who if they might find out, having spent their money, that the person is a man of straw, and then the publisher of it escapes away in the smoke. Well, is that just?
No, I don't accept that. Let us take a situation where you see that you yourself have been defamed on, say, Twitter by an account ABC123. If you want to take action at the moment, you will find it extremely difficult, because we're told that these big global players are incredibly reluctant to engage. But under my law, if this becomes an act, you will have the right to say to that global organisation, identify ABC123 in a manner that allows me to take defamatory action against them in the courts, or I will take defamatory action against you. I think that's a much better position for the individual.
Well, would the much better position not be, yes, the statutory duty to identify without sacrificing the right to pursue the platformer, so as you could sue both if necessary?
And what do you think the effect on freedom of speech would be if you introduced that chilling effect?
Well, if you're going to have your provision whereby the initial libeller or defamer must be identified, that you could say is a chilling effect on freedom of speech. I'm simply guaranteeing that those who defame don't get away with it, that they can be identified, and that the publisher of that can also pay the price.
Well, it would also be my impression that many people who are defamed simply want justice. They want a correction. They want the truth to be published, and they're not interested in large quantums of financial compensation.
Well, I thought one of the arguments about this from your side of it was that libel was out of control, and there you had to put some brakes on it because companies like UTV and others couldn't afford to pay.
Well, that's an interpretation I did not intend you to take.
I see. Just let me ask you one other thing about this issue of serious harm, which really is related to the extent or the quantum of the libel. You don't seem to have given much thought to the fact that by increasing the jurisdiction of the county court, we could take care at very low cost of a lot of minor defamation cases. At the moment, the jurisdiction is at a farcical level of 3,000. But if it was raised to an appreciable level, then a defendant who says, well, this may have caused you harm, but it's not causing you serious harm, could make an application before the Master in the High Court to remit the case to the County Court. If the Master in the High Court agrees that it's not a serious libel, but there's a potentially is a libel, then it's remitted, and then you're in a situation where costs are limited for both sides. Is that not a much more practical way to approach the problem of small defamation cases?
Well, the approach that I've taken is to bring us back into line with the defamation laws it applies in England and Wales. That said, what you're proposing sounds to me to have a significant degree of merit to it, and perhaps that could be something that the department could take on board if we were to accept an amendment that put that statutory duty on them to continue to scope out and investigate other reforms. To get back to this idea from Dr. Scott, that what I'm proposing is basically a good start, but which needs to be appropriately amended as we go forward.
Thank you. I'll leave it there. Thanks.
Thanks, Jim. Keith?
Okay, thank you, Chair. First of all, I just want to add my comments on the rest of the members have done so far regarding the despicable words against Diane Dodd. I think it's absolutely disgusting. I think it's, no doubt it happens to all of us to some extent, not exactly day in, daily. I think if anybody's listening out there, that you see some people on social media and they're wishing you Happy New Year, and 2 hours later they're attacking you verbally over something, and their Happy New Year didn't last too long, or their new change that they talk about. So I think it's up to everybody out there. Be man enough or woman enough to come speak to the person at their office or at their, not their doorstep, but come and talk to them. Don't do it over social media, because they're not as big a people whenever they're sitting there on the sofa. So anybody out there listening to it, I think they need to listen to those words. Mike, you referred there to a little lie or a little error, and there was a journalist in your seat there a few weeks ago referred to a little lie. What's the definition of a little lie to get a lie to get a story? That could then be defined as a little error. That has a big impact. Do you think it's acceptable, to tell lies to get good journalism?
No, absolutely not. Absolutely not.
So, how do you then not control journalism with respect? How do you police journalism? Because they can't say what they want. So, how do you get that balance right? And is the balance tipped the wrong way currently?
Well, in terms of journalism, there are bodies who investigate and regulate journalism. The balance, as I said when I was in front of you previously, is it's a balance between two rights which are competing, which is the right to freedom of expression and the right to protect your reputation. So it's always going to be a balance. And it will be necessary from time to time to adjust the balance. Our laws predate the internet. So there is a prima facie case for saying we need to look at our laws to take effect of this new broadcast and communications medium, which is incredibly fast, can be marvellously informative, but as we all know, can bring out the absolute worst traits of the human condition.
Just on your point about who sort of polices the journalists, we got a document in the table packs from Professor Chris Frost, National Union of Journalists, referred to, there have been 3 complaints from Northern Ireland in the last 15 years, 3 complaints. And my understanding, and you can correct me if I'm wrong, that the complaints now can only be taken by other journalists. So members of the public can't even complain to the National Union of Journalists to say there's an issue. So there's only been 3 complaints about members from Northern Ireland in the last 15 years. So if a member of the public can't complain about journalists, who can?
But there's 3 complaints to the National Union of Journalism.
In the last 15 years?
Yeah, but there's also, because I'm having a mind blank.
There's more than that, obviously.
There's an independent...
IPSO.
Yeah.
IPSO, yeah. There's IPSO.
Yeah. Okay, and sort of a point then that I prefer Jim previously picked up on it, and both Jims, to be fair, picked up on it. This operator of websites, clause 5. So the difference, what's the difference today? Give it to me in layman's terms, Mike. What recourse has an individual today? And if your bill came in, so what can that individual do today to go off the websites? And if your bill comes in, so what's the strength in clause 5 to, and I don't want to pick the odds, but whoever.
The difference is it introduces a statutory duty on the operator of the website to give you the information that you need. So if ABC123 has a go at you at 5 o'clock this evening on any website, maybe one of the local newspapers or Belfast Live or whatever, and you go to them and you say, I need to know who ABC123 is. I'm going to take them for defamation. You're entirely in their hands. Are they going to tell you or are they not going to tell you? This bill says you will tell. And if you don't, then you're going into the witness box. You're responsible.
But does that not, back to Jim Alistair's point, does that not put the straw man, the individual that doesn't exist? So they've given you this person and you're chasing your tail to try and find them. So what more can you put on operators of websites to say, no, those people must be identifiable. They can't be ABC123. They must be Mike Nesbitt from wherever. Can that not be put into that?
You could, yes, and in theory you could put that in, but again, I say to you, what will the effect of that be on free speech? To what extent will that chill free speech? To what extent will the operators of the website say, we're not going to do this. We're not going to take reader comment. Okay, we're going to publish our story in our newspaper and we're going to put it up online, but we're not allowing any comment from the readers.
But you can't make, as you know this, walk up to a man or woman on the street and say what you want. You can't do it. You can't say what you want to a man or woman on the street. You just can't walk up to someone and say what you want.
No.
There's a more of a in your face. No, you can't say that.
Yeah.
But they can do it online. So why can they not? If you want to say something to somebody online, you should be doing it on the same basis as if you're talking to them face to face. But people hide. People hide behind the screen.
Yeah.
So what's the problem with people being asked to give me your information? Where do you live, Mike? You're setting up a new Twitter account. Say what you within reason what you like, but it'll come back and bite you if you cross the line. What's the issue with that?
Well, now
you
you're
talk about free speech. It's free. I can say what I want, but if I go too far, the buck stops with me.
Well, then what you could do, and it's separate from this bill, is if you're the operator of the website, say niassembly.com, and you're in charge of it, and all the other 89 MLAs can go on and type whatever they want. What you could do is say, before you get an account, you sign a contract with me. And in that contract, you guarantee that you will not defame anybody, and if you do, that you will take full responsibility. But that's a separate issue.
Yeah, fair enough. Yeah. Okay, thank you, Mike. Thanks.
Matthew?
Thank you, Chair. Thank you, Mike, for it's been really thorough today. I suppose, Mike, could I ask you a little bit to one of the things that's come out of, particularly today, but other evidence sessions too, and it goes back, in fact, some of the questions Keith just asked, get back to this point. Do I sense a conflation of, in scrutinising this bill, of the questions of online harm and bullying, horrible, vile abuse from people online, and defamation, and they are two separate things. I should add, of course, like everyone else, I was utterly disgusted by the remarks that were made to Diane Dawes, which are possibly the most shocking example of, or one of the most shocking examples we've seen here of just the depths of depraved comment that people are willing to make anonymously on social media. But isn't it important that we distinguish between abusive, bullying speech and defamation, because they are two different things?
They are, but I think they conflate, Matthew, and I don't want to get into the detail of the tweets aimed at Diane Dodds, but one of them that I read was clearly defamatory as well as abusive. Clearly defamatory in ascribing to herself and her husband attitudes and behaviours. Totally defamatory.
Okay.
So,
Well,
I do take your broad point, and that's why I do think that what I'm proposing in Clause 5 goes a certain distance in addressing issues. We do need broader legislation beyond the remit of this jurisdiction to look more broadly at online and cover the full gamut.
I think that is agreed. I think the point that there is a wild west of speech online that social media platforms are not properly held accountable for in terms of their role as publishers of that content is a point that's well made. But in one sense, what your bill does is it at least introduces a little more legal obligation than exists at the present, or a little more legal recourse for people who have been defamed on those platforms than exists at the minute, because at the minute there's very little at all, and you may be fortunate enough that you are able to, if you have a lawyer, and it's good that certain lawyers are expensive enough. Paul Tweed talked about this himself, they have means of being able to go and find out VPNs and where people have posted information from, because of the literal VPN address of the device. But that at the minute is something that is, there's no legal certainty around that frame. Not only is there not legal certainty, you have to be able to find the right lawyer who has, as it were, the equipment and the expertise to be able to find has the technical expertise to be able to find that person. So at the minute, it is a total Wild West.
Yeah, I agree.
Yeah. Okay. In relation to the point about the body of law, because this is a point that's come up at present, it's come up in our evidence on multiple occasions, is the fact that previously there had been Northern Ireland could draw from, judges could use, and indeed lawyers could use case law in England and Wales, but obviously the divergence post-2013 means that hasn't happened. It may be worth you reflecting a little bit on in a sense, the fact you talked before about the risks of not taking action or not passing this legislation, or indeed any legislation. That will mean that Northern Ireland will become there'll be even less case laws that we're to refer back to, and it'll simply be a much more of a place apart in terms of defamation law. It may be helpful if you could say a little bit more about that as a concern, about the risks of not taking action, what it might mean for the application of defamation law here.
Well, I would just repeat what Professor Scott said at paragraph 19 of his note, which is that it becomes increasingly inappropriate for judges here to rely on English law as a guide. And in terms of building up case law, I mean, the number of defamation cases that go to trial, in and around 30 to 36, something like that, per annum. So there's not a huge volume of generating case law precedents. So I do think we're better off, as Dr. Scott argues, now arguably a more pressing issue than it was back in 2016. So,
and indeed, it was confirmed by one of the lawyers we took evidence from, Mr. Tweed, that very often his work does involve simply a phone call to a publisher, whether they're in Belfast or London or elsewhere, to have a conversation about content, and it's not just settled out of court; it's settled long before a writ is even drafted, let alone issued. Is there a risk that simply becomes ever more the default in the absence of in the absence of any of reliable case law?
I think it does become the danger is it becomes more prevalent without a kind of serious harm test. And I'm going to admit to something that I'm not at all proud of. Some years ago, I felt I was being followed, let's say, on Twitter. There was a particular correspondent who every time I posted something would post something critical of me. And I did get a solicitor to contact this person and basically say, if you don't stop, we'll see you in court. And they stopped, but they didn't stop, by which I mean they stopped posting against me and started posting against somebody else. And, you know, that's not great, is it? So I think we need better. And if you have a serious harm test, then, you know, the phone call or the letter from the lawyer does not necessarily carry the same weight anymore.
Indeed, because there is a more reliable piece of there's a piece of legislation against which the claims can be tested in court. So the publisher or indeed the poster of the information has the choice whether to defend what they've said in court or not. Okay, thank you very much. Cheers.
Thank you.
Sorry, Pat? Sorry.
Thanks very much, Chair, and thank you, Michael. Come to wish you a Happy New Year as well.
Happy New Year
I
to you.
also, Chair, wish to share the comments on the awful posts which went against Mrs. Dodge and her family. I want to just start with the clause by clauses that come back. I don't want to spend too much time on it, but I think I want to share with your opening comments. For the Department to write, first of all, this bill is a private member's bill, I really find that awfully difficult to accept. They should have been giving you all of the help that you required in order to make sure from 2013 the Department has previously outlined its concerns. I would have to question what help they give to you, or is it a blocking process? The longer I stay here, I feel sometimes like some officials are like trying to pull you back. I have to commend you as a fellow member in order for trying to bring forward this bill. And from the people that have responded and the organisations that have responded to it, it shows that it is much needed. I want to address that, and sure, you have already stated that you intend to write a letter. I would
with the
committee's consent, but I've also gone here, and I'm going to just bring it up to Mike here as well. Some of these issues, particularly around social media, are likely to require broader consideration and will be both outside the remit. Well, I think that you're trying to bring it within that remit. That's what you're trying to do here, and this strengthens the debate and the argument. At least it's moving and showing movement. And by saying that you're open for 2 years, that's what you said, if we can make better law, is that correct?
Yes.
Can we speed this up? Can we help you with the remainder of this mandate that is here? Or can we get the brakes off, which I feel, listening to the evidence coming out here today, is being put on you as a private member? Is there do you find hope that with the limited time we have, we're able to progress this, your bill?
I think it is possible to get this bill over the line before the end of the mandate, which I believe is the 25th of March. So, you know, time is not generous to us, but it is certainly available to achieve it. In terms of cooperation from the department, I mean, in fairness, because what I was doing was basically transposing existing legislation, the 2013 Defamation Act as applies in England and Wales, there was no call on drafting. There was no particular need to go to the department. There was a need to go out to consultation, which I did following Guy Black's intervention in September 2013. But then Simon Hamilton, who was the finance minister of the day, decided that he would like to bring in the Law Commission and basically task them with a deep dive review. Now, some people said that was kicking the can down the road. I took an alternative view. I could have pressed on when I met Judina and Andrew in the Commission's offices. But I took the view that, you know, my online review, my consultation, was shallow enough. You know, it was attracting certainly, you know, the likes of Penn and the National Union of Journalists, the usual suspects, if you like. But Andrew went much deeper, and I felt that that was a good thing to do. And when his report came out in 2016, it was very welcome. Now, he took a different tack from me on certain aspects, but what he did say was that my bill and his alternative bill were both desirable. And he hasn't moved off that, because in his verbal evidence to you the other day, he said, my bill would be a good starting point. So I'm happy with that. In terms of the officials, I don't know them. Never met them. I wouldn't know them if they walked through the door next. But I am really taken aback. I think they've overstepped their mark.
And my point as well, that's what I'm making, as I'm trying to make with you.
And you know, I can't speak for the Minister, but I would be really surprised if he was entirely content with everything that the officials have done and said.
Yeah, I would doubt if the Minister was, and that's just my own personal view on that. But I can see the amount of anguish and hurt it probably has given to yourself, because it's difficult to take on a private member's bill.
I was just taken aback by the attitude, but you know, it is what it is. I'm much more focused on the fact that Professor Scott, as he is now, has moved since 2016. Considers the non-jury trial to be a much more significant development than anybody imagined, that consistency with England and Wales is a more pressing issue than it was 5-6 years ago. So that I do think that if we go with this bill, but put in that clause that says...
Year review.
And is it 2 years? I mean, is it 18 months? Is it 3 years? I don't know. But whatever seems reasonable. But if you say we've got to wait to see what Dublin does, or we've got to see how the new Scottish law pans out, what happens if, as we're coming to that conclusion, Westminster say, this isn't 2013 needs updated? We're going to have to wait again. So why not do this as a good start, as Professor Scott has described it, but recognise that its shelf life is going to be potentially very limited?
Thank you, Chair.
Okay, thanks. Any further? Gemma? Thank you. No, sorry, that's okay. Thanks very much indeed. Mike, thanks very much indeed. Thanks very much indeed for coming and giving evidence at this time. Team, there's a couple of actions we need to take out of this. The first one is, as already alluded to, I would like to write on behalf of the committee from me about the particular tone of the note that came from the department. There's been a couple of occasions in the past that the department has written in a way on private members' bill, not just this one, on another one, that I think has been less than respectful on the particular occasion. And I would like to sort of iterate that point to them, and I would like to give them their opportunity to reconsider their commentary and, if necessary, issue an apology to the member to do that as well.
And withdraw. In the letter, we should ask it for Chair to be withdrawn.
Okay, thank you. If we're content.
Agreed.
Agreed. Okay. Members, are there any further actions or any other oral evidence the members wish to pursue at this stage in respect to the bill?
Chair, is the committee content to also write just to the bill sponsor, just to clarify on the amendments, firstly on his review clause amendment. I think also maybe the suggestion that Mr Alistair made about the jurisdiction of the county court, just to see, not to, expressing an opinion, but just to see if the bill sponsor is considering bringing forward a related amendment, and also the bit about clause 11, which the chair asked about, and I think I wasn't quite sure what the bill sponsor actually said. The idea about an amendment which would make it clear that the judge had discretion in respect of whether a defamation case would be heard by a jury or not.
Yep.
Is that agreed, Chair?
Agreed.
We obviously haven't seen the wording of Mike's amendment on this, but what standing does the commitment to the review, or whatever we call it, in 2 years' time, that goes into the body of the bill, and then it's incumbent upon the Minister to do that?
you could do, or you could seek an assurance from the Minister that he's going to do it. You could do that, or you could put it into the body of the bill. I've seen that kind of thing. The Caravans Act, I'm pretty sure, had such a review clause in it. So,
yeah, that would be helpful, because I think this is a rapidly moving feast, as it were, and we may actually end up passing something, or at least putting it through this committee, that we're not actually 100% happy about. But at least if I knew that in 2 years' time, when things develop, we would have the opportunity to come back to this. And I presume it would be this committee that would be
Finance Committee,
consulted about that review and have an input into it.
Okay.
That would make me happier, and I think Mike's pulled out a bit of a rabbit out of the hat in that respect. But at that stage, of course, we'll know what Scotland has decided. The Irish Republic also, not that we should be bound by the Irish Republic, but it will have an influence, because, of course, you could get a cross-border tourist-type situation that's developing as far as defamation is concerned, because some of these publications will definitely have a cross-border circulation. So I'm still not awfully happy, but I think that's maybe a sensible way forward.
Okay, thanks. And also the online harm bill. Jim, you want to come in?
Yeah, I just want to say the issue about the level of the jurisdiction of the County Court on defamation, I don't think that would fall within the ambit of this bill. I think that's a Department of Justice matter, but it certainly is something that our report could strongly recommend, but maybe I'm wrong about that, but I don't think this bill could change the jurisdiction levels of the County Court.
Well, we could put it in our report if we were content.
Chair?
Yeah, Alicia?
Chair? Yeah, Chair, just there's an issue I raised just through the use of text with the clerk, and I asked the clerk to check this one out for me. But I know that in other committees and so on that I've been on, that the clerk to those committees has pointed out about the neutrality of a background. I have to raise this issue just in relation to Jim Allister. It seems we would like product placement. Is he marketing the book or what there about security forces? I'm not that sure. But at the same time, the clerk seemed to imply that there's no code of conduct in relation to the neutrality of background. Well, I would say that's exceptional for this committee.
What?
So I'd like the clerk to check that out for me.
okay, I will do. I'm unaware of guidance in respect of neutrality of backgrounds for members attending remotely, but I'm happy to take that away and come back to the committee, Chairperson.
Oh.
Budget, Chair.
So, go ahead. I must admit, I must therefore make I think I probably have to refer myself again, because if anybody's looked at my background with my shelves of everything that I have in mind, I have a copy of that very same book that Jim has in my shelf that has appeared on numerous Zoom calls that I've done on behalf of the committee. And I think particular sort of various pictures I've had on sort of the bulkheads, sort of naval expression for walls that I've had in many of my things would refer to my previous military past and existence, and also sort of members of parts of my culture as well. So don't really see where that is, but your point is noted, Militia.
Well, quite clearly, your position is different from that of other committees, Chair, and maybe it is that you agree there with the clerk, but I'd like to have clarification on that, because it has been pointed out in other committees, and I think that it's appropriate as well too.
Well, Chair, can I make it absolutely clear that neither Mr. McCune nor anyone else will dictate the contents of my study? I note that the book that offends him is one that exposes the vicious, vile terrorism of the IRA, and I have no apology to make to Mr. McHugh or anyone else for having such a book in my study.
Okay, I think the point is duly noted across, and we shall move on to the next item of business. The next item is, that concludes the evidence taking for the bill. The committee will be asked to deliberate on the bill and decide on informally on amendments next week. Shortly thereafter, members will be asked to set out their views on the clauses of the bill formally, as the committee stage is set to conclude before the end of the month. Okay, thank you. Moving on to the next item on the agenda, non-domestic rates valuation coronavirus bill committee stage committee report. The committee will now consider the draft report on the committee stage of the non-domestics rates valuation coronavirus bill. The draft report is at page 142. The following written and departmental oral briefings on possible amendments to the bill, the committee elected not to seek to amend the bill. You still content with that? Yes. Invite members to comment on the draft report, so I'll go through that. Is the committee content with the introduction from page 148? Is this agreed? I'd like you to say agreed.
Agreed.
Agreed. Is the committee content with the committee approach and acknowledgement at page 152?
Yes.
Is this agreed?
Yeah.
Agreed. Is the committee content with the committee deliberations section from page 153? Is this agreed?
Yeah.
Agreed. Okay. Is the committee content with the clause-by-clause scrutiny section at page 160? Is this agreed?
Chair, could I make a comment?
Yeah, go ahead.
I remain disconcerted and unhappy with this bill, and whereas the report is an accurate reflection of our deliberations, I just want to make it clear that I do not feel bound by this report to be unable to speak against and vote against this bill when it returns to the House.
That is your right as an MLA. It's duly noted. Okay, so therefore, as the contempt of the clause-by-clause scrutiny section, bearing in mind Jim's comments on page 160, is this agreed? Agreed. Is the committee content with the list of appendices at page 161? Agreed.
Yes.
It's just worth saying, Mr. Chair, that since we agreed this, things have moved on, and there's been another raft of closures. Obviously not as extensive, but for instance, nightclubs have been closed in their entirety. That hasn't restricted my social life greatly, I'd have to say. My impersonation days of John Travolta have long since passed. But also there are restrictions on hospitality. So just taking up on Jim's point, it's worth saying that there's further pain has to be borne, and that still can't be, they still can't lodge an appeal on the basis of that. Mm-hmm. And, we don't know where we stand. These things could go on and on and on. And I'm just, whilst I think overall we have to agree this bill, it's a very open-ended situation we're now in of constant waves of restrictions. But whilst I, and the floor of the House, will express my concern we're in this position, I think I can't really have my cake and eat it, in that I'll put it through the committee when nobody's watching and then stand up and beat my breast in the chamber and say this is terrible. Now, not that I'd accuse the Honourable Member for Antrim North of doing that, of course, but so therefore I think we're still in a position where we as a committee are duty bound to reluctantly give our support on the floor of the House to this, and that would have to be reflected in the Chair's brief.
Well, I think one of the things, and I'll be talking with Peter obviously with the Chair's brief as well, but I think for all of us this is exceptional legislation and exceptional times, and I don't think any of us are, at any stage are we happy that we're having to do this, but it is the reality of where we happen to be, which is why we didn't accept the accelerated passage. We went back, we took the additional evidence, we took the time to properly scrutinise the rest of it, and we understand in these exceptional circumstances this is the case where we be, and I will be reflecting that in my remarks, and also be reflecting the views of the committee as we go through.
Also in your remarks, Mr. Chair, and far be it from me to suggest what you should say, but I think we would like an assurance to be included in the remarks on the spending of the 50 million, that we as a committee will be kept constantly up to date with that, because that's a crucial element to try and ameliorate some of the pain that's been caused by this.
That actually is a very good point. I think the committee would be agreeable to that, because I think the fact that one of the reasons why we took a degree of comfort was the fact that the £50 million would be ring-fenced to be able to be in rate support. And we'd be informed that the rate holiday up until the end of June for those affected businesses, that was already outlined by the Minister as part of the 50 million, if that's my understanding of it. But I think it would be useful, quite rightly, to reflect that in the remarks to make sure that money has been appropriately spent in that direction, if we're agreed.
Chair, just one other point, if I may ask. Jim referred to a nightclub, for example. So if that nightclub had went back, let's say early December, as part of the Reval 2023 and indicated what the position was at that stage. Can that same nightclub go back with additional information to say things have now changed? So in other words, will LPS take 2 bits of information from the one business?
Okay.
Call it an up-to-date bit information, call it what you want.
So, Chair, to answer the member, I shouldn't be giving evidence on behalf of the department, but I think what they told us was there's an antecedent valuation date, 1st of October.
Yeah.
2021, the new valuations wouldn't come out until 1st of April 2023. So anything that happened in between, before this bill passed, would be a basis for an appeal on the valuation. The bill passes, so it will not be the basis for the valuation. But what seems to have happened is, number one, the executive has intervened, provided a rates holiday, and may, I guess, intervene again with other supports. Additionally, that's how they're going to deal with it. They're going to deal with it in that way by providing rates holidays and presumably grants, but they won't be able to appeal on the basis of their valuation.
Yes, but can a business provide additional information? So a business could have provided information in early December.
Yes.
That a nightclub in Kilkeel, for example, but that now has changed. Can that business go back? The gym frequents. Can that business go back? Can that business go back and say, here's an additional information? Or can you only get one shot at it, is my point?
I think the department...
It'll be a query, because they did indicate to LPS that they would listen to concerns of businesses. So therefore, the goalpost...
Should take as many.
Yes.
That is my recollection of what the evidence that the department provided, that what they said was they would look at the overall impact of the coronavirus on the economy, and that's how it would work its way into the valuation process. I think that's as much as they said, and I think the member may have even asked them when they were here, and they didn't give a very precise answer. It's fair.
Matthew?
Thank you, Chair. It's really on the same point. I just think it's worth noting, and perhaps it's for you to, in your remarks, as Chair, when we come to the next stage of the bill, simply to point out that there were in the time between us voting against accelerated passage and for this to go to to committee stage, there was a new and not unpredictable, but not foreseen at that moment development in the pandemic, and so that reinforces the in principle concern, albeit we have heard pretty detailed evidence as to why this legislation may be essential and unavoidable. It still doesn't answer the permanent point that we need to know that these businesses are still going to have protection if there are further developments in the pandemic. Obviously, as Jim Wells said, there have been some sectors that have been closed down, others have had their activities restricted, some more. Hopefully those won't be long lasting, but we just need to reiterate the point that that those businesses, having had the potential for appeal on this basis removed, there is a kind of ongoing commitment to doing what is necessary to protect them or to compensate them to some extent.
Yeah, or to support them. Okay, thanks.
Chair, hopefully page 146, paragraph 2, would address that in the executive summary. Because the member is right, while I was writing this, things were happening, and in anticipation that I thought that's where members would be, I hope that captures that. But the Chair will cover that in his remarks.
Okay, Tim, are we content with the executive summary at page 146? Are we agreed?
Agreed.
Yep. Great. Is the committee content with the title page and 142 to order the report to be published as the 5th report for the Committee for Finance? Is this to be agreed? Great. Is the committee content to include an extract from today's minutes in the appendices of the report? Is this agreed? Agreed.
Chair, is the committee also, because I forgot to include this, is the committee also content for the clerk to share the report with the stakeholders who very kindly gave evidence to us before Christmas?
Yes, I think we are agreed to that. Thank you very much indeed.
I suppose...
Go ahead, Jim.
one of those who gave evidence obviously did a fantastic job, because he was subsequently given the MBE in the New Year's Honours list, and I'm wondering, is it incumbent upon us as a committee to congratulate the spokesman for Hospitality Ulster on his achievement? Obviously, it was based entirely on his evidence to our committee that was awarded. I don't know if that's in order, but certainly I think the committee should at least note that achievement.
I think we're content. I think we'd be happy to note that achievement. I've already contacted Colin separately and sort of congratulated him on his award as well. But thank you very much indeed. I'd just like to thank all the members and indeed the staff, and particularly yourself, Peter, for the hard work and sort of the contributions the committee stage to this bill and getting us through to this point as well. Thank you very much indeed. Move on to the next item on the agenda, subordinate legislation, decapitalisation rate. The committee is asked to consider the SL1 at page 164, which is entitled The Draft Valuation for Rating Decapitalisation Rate Regulations Northern Ireland 2021. All non-domestic properties are valued for rates by reference to an estimate of rental value, but as some of these properties are rarely rented, it is necessary to value them with reference to construction costs. The decapitalisation rate, often referred to as the decap rate, is a conversion factor needed to derive an annual equivalent or rental value from the depreciated construction cost estimate. There are two rates: a standard decap rate for most specialised properties and a lower decap rate for education, healthcare and church properties. The proposed rule will allow the Department to set the decap rate following an ongoing consultation. The rule will be subject to negative resolution and is one of a number which the committee will be asked to consider today, which refer to rates. Any comments? Therefore, if we are content, is the committee content with the policy objectives of the proposed rule, and is it therefore content for the Department to make the rule? Is this agreed?
Agreed.
Agreed. Okay, thank you. Next item on the agenda, subordinate legislation, rate setting date. The committee is asked to consider the SL1 at page 169, which is entitled The Rates Amendment Regulations 2021. These regulations amend the date by which a district council must make their district rate for a forthcoming rating year from the 1st of March to the 15th of February. This is a return to the pre-pandemic practice and is being adopted following advice from Solace. The rule would be subject to negative resolution. Do we have any comments? Therefore, is the committee content with the policy objectives of the proposed rule, and is it therefore content for the Department to make the rule? Is this agreed? Agreed.
Agreed.
Next item on the agenda, subordinate legislation, regional rates. The committee is asked to consider the SL1 at page 174, which is entitled The Regional Rates Order Northern Ireland 2022. The purpose of the draft rule is to set the amount of the domestic and non-domestic regional rates for the year ending 31st of March 2023. The details shall be laid out in the statutory rule and accompanying documentation and will reflect the final executive budget settlement. The final regional rates order will reflect the revenue levels determined within the executive budget for the 22-23 year. The rule will be subject to affirmative resolution assembly procedures. Do we have any comments? Therefore, is the committee content with the policy objectives of the proposed rule, and is it therefore content for the Department to make the rule? Is this agreed? Agreed. Next item is subordinate legislation, small business rates relief. The committee is asked to consider the SL1 at page 179, which is entitled The Rates, brackets, Small Business Hereditament Relief, brackets, Amendment, Regulations Northern Ireland 2022. The proposed rule will continue the small business rates relief scheme until the 31st of March 2023. The scheme provides relief of between 50 to 20% for businesses, depending on rateable values where the NAV is less than £15,000. The total cost is given as £20 million in 22-23. Information including exemptions on the small business rates relief scheme is appended. The rule will be subject to negative resolution assembly procedure. The rule is also subject to the 22-25 draft budget being agreed. Members, any comments?
Well, Mr. Chairman, I think we would all very strongly welcome this renewal of a much-needed and very beneficial scheme, which particularly for our small high street traders has been a lifeline. And I'm just relieved that the 25 million is available and that it's been granted to 2023. Mm-hmm. And long may that continue. Like all of these schemes, it is dependent upon the budget being agreed overall. But I think this piece of legislation goes forward, hopefully with the committee's strong endorsement.
Draft budget is due before the executive on, or
That consultation,
is that for consultation?
that ends on the 7th of March.
Yeah.
So I would imagine there will be, I would think the minister will make a statement, maybe like at the last plenary, I would have thought,
Okay.
I guess.
Okay, so we need to keep a careful eye on this to make sure this does go through.
Go through.
Okay. Are we content and also to keep for our committee to keep a careful eye on this as we head towards the end of this mandate? Agreed. Okay. Therefore, is the committee content with the policy objective of the proposed rule, and is it therefore content for the department to make the rule? Is this agreed? Agreed.
Agreed.
Subordinate legislation, transfer of housing-related functions. The committee is asked to note correspondence including an SL1 at page 186, which is entitled "The Housing-Related Functions of the Department of Finance exercised by the Housing Executive Regulations Northern Ireland 2021." The proposed regulations will transfer administration for housing benefit and low-income rate relief from Land and Property Services to the Housing Executive in May 2022. Did we manage to ascertain which part of the Housing Executive it's going to?
I have not.
Okay. Just one of the reasons for that, because we are aware of legislation that is going through about sort of mutualisation of part of the Northern Ireland Housing Executive, and I'm not quite sure from this. And again, one of the things I think we should be writing to the committee after this is to find out which part of the Northern Ireland Housing Executive this is being proposed to be transferred to. As members are aware, the Controller and Auditor General qualified the LPS accounts in respect of housing benefit relief overpayment owing to official error. The committee may wish to seek clarity from the department as to whether the housing benefit relief will also transfer from LPS to the Housing Executive, which part of the Housing Executive as well. The appended proposed regulations have been brought forward by the Department for Communities and were considered for the Committee for Communities on the 16th of December 21. Does the Committee for Communities not ask the question which part of the housing?
Yes, they should. Well, I think they're currently on holiday.
Right.
Well, no, I think they met on the 22nd of December, and I just got this shortly after that. So.
Could we have an informal discussion?
I've fired them off an email. I just haven't come back yet.
Okay, thanks. The Committee for Finance is therefore simply asked to note the regulations. Okay, are we happy to content to note the proposed rule? Okay, content. Thank you. 14 January monitoring round, written briefing. In line with the Functioning of Government Miscellaneous Provisions Act 2021, the Department has provided a copy of its written submission to the monitoring round on the 4th of January 2022. The committee is asked to note this at page 194. I just want to bring this up. Okay. A ministerial statement on the outworking of the monitoring round is expected on the 24th of January. The Department is expected to brief on the overall outcome of January monitoring for all departments after this. Any comments? Therefore, are there any actions or questions members wish to pursue at this time in respect to the January monitoring rounds? Okay. Are we content to note the written briefing? Content. Agreed. Next item, move on to the correspondence. Correspondence index. There's 18 received items of correspondence at page 219. The first is on energy payment supports. The committee is asked to note at pages 222 and 224 responses from the Department for Committee for Community in respect of energy fuel poverty support schemes. Further information on the prospective scheme has been published and more may follow in January monitoring. Are we content to note the correspondence?
Done.
Great. Windfall taxes. The committee is asked to note on page 255 a response from the Department to the Committee for the Economy in respect of windfall taxes and the suspension of VAT in order to address rising domestic energy bills. Committee content to note the correspondence? Great. Yep. Next item, notice of statement. The committee is asked to note on page 228 a notification from the Minister in respect of his pre-Xmas Christmas statement on the budget. Are we content to note this correspondence? Agreed. RHI closure. The committee is asked to note at page 250 a response from the department indicating that owing to legal delays, the 91 million for the RHI closure fund will not be used in this mandate. The agreement of Treasury is sought to draw down the money in the next mandate. Can we write to the department and ask what assurance they have from the Treasury that they're going to be content for this to happen?
Agreed.
Go ahead, Keith.
I just noticed that the second paragraph from the last chair, a response from the Chief Secretary Treasury is pending. However, this is expected to be confirmed.
Yeah, but you haven't got it.
No, it's pending, so that can mean.
Yeah, exactly. Yeah, so, and it is £91 million.
Yeah.
Yeah, I think I would like to get a bit more clarity.
Yeah.
And I think the Secretary of the Treasury, rather than saying pending, might actually say, yes, we're willing to consider it during the next mandate. Because I'm not sure, but I thought there was to be some form of closure on this before the end of this mandate, and yet here we are. It doesn't indicate from that it looks as if there's going to be any closure between now and sort of the end of the mandate. I think that might be of interest not only to those who in receipt of RHI, but also in sort of the general management of the whole RHI issue, full stop. Are we content to note this correspondence with the agreement to contact the department for a bit more than just pending as the assurance on £91 million? Thank you. Next item is 15.6, the Audit Committee. The committee is asked to note at page 253 a further exchange between the Audit Committee and the Department regarding the former's commentary on the Northern Ireland Assembly 22-25 draft budget. Are we content to note this correspondence? Agreed. Changing places. The committee is asked to note at page 261 a response from the Department of the Committee for Communities regarding the consultation on changes to the Building Regulations Technical Handbook in respect of the changing places toilet facilities. Is the committee content to note this correspondence pending the outcome of the related consultation? I think we have to wait for the consultation. Yeah. Are we agreed?
Agreed.
Okay. Northern Ireland Civil Service absence rates. The committee is asked to note at page 262 the Northern Ireland Civil Service quarterly sickness absence for July-September 21. This shows a 50% increase in sickness absence since this time last year, taking sickness absence back to the pre-lockdown levels. Are we content to note this correspondence, or do we have any comments, Jim?
Well, I'd like to know a bit more about it. Is it because of coronavirus? Well, obviously, there's not much we can do about that. Or are there other factors? I would say they're going to look pretty horrendous for the period December, January 21-22. What's actually going on here? That's all I think we need to ask.
Yeah. I think are we content to ask for further, or would the committee wish us to write for further clarity? I think I would.
Yeah. Chair, can I make a comment?
Yeah, go ahead, Jim.
I think the really startling comparison is in the table at page 266, where we're comparing the summer quarter, July to September of 2020 and 21, and we note, and that should be a relatively COVID-free period. Mm-hmm. We note that the percentage of available working days lost moved from 4 to 6%, and that the cost of that is now almost £10 million in that one quarter. Mm-hmm. Multiplied up, that's a cost to the public purse of about £40 million per annum. I certainly am struggling to understand why over those two summer periods there should be such a dramatic increase in the sickness levels. And I don't find them explained.
I think it would be useful for us to have some more detailed explanation on that, if we were content. Agreed. Next item on the agenda, census. The committee has asked to note at page 280 a response from NISRA. The committee queries read the census. NISRA indicates that it will act on the Office for Statistics regulation report in due course. Any comments? Okay, we content to note the correspondence? Agreed. Next item, legislative consent motion. The committee is asked to note on page 285 ministerial correspondence of a possible legislative consent motion on the Architects Act flowing from the GB legislation relating to the Grenfell inquiry. Peter suggests that the relevant evidence session, that we have a relevant evidence session to be arranged in February. I think that would be quite useful. Bearing in mind, I think that it will bring in changes in how architects are likely to, their training they're likely to do and what they need to do that as well. Are we content for Peter to liaise with the department and relevant stakeholders and make the necessary arrangements on this?
Yep.
Agreed. Thank you. Next item, public sector exits. The committee is asked to note on page 290 correspondence from the department in respect of the Public Sector Transformation Fund, referencing the longitudinal report recently noted by the committee. That report refers to 6,000 voluntary exit schemes. The total voluntary exit scheme cost was around 323 million. The Northern Ireland Civil Service accounted for around 90 million of this. The average cost of an exit across the public sector was about £42,500. The staff age profile of the participating organisations in 2020 appears to be nearly identical to 2016, before the voluntary exit scheme took place. The department contends that it was not the objective of the voluntary exit scheme to address age profile issues. The department disputes the suggestion that all departmental Northern Ireland Civil Service staff have been replaced. But the figures are just about the same, aren't they? And the profile and the grades are just about the same. And the costs are just about the same. Plus inflation. Less the money was spent in the voluntary exit scheme.
Indeed.
Right, am I getting any of that wrong?
I don't think so.
Right, okay. However, as members will recall, the new head of the Northern Ireland Civil Service recently advised the committee that the staffing levels of the Northern Ireland Civil Service had returned to the same levels as pre-voluntary exit scheme levels, albeit with higher levels of temporary and agency staff. The department's related commentary is therefore, to say the least, difficult to understand. Is the committee content to write to the department and seek clarity as to what the benefit actually was of the achievements of the Public Sector Transformational Fund voluntary exit scheme? Because, to me, I'm afraid I can't actually see it unless I'm missing something. Go ahead, Jim. Matthew, sorry. Matthew?
I was simply going to make the comment that I think this shows what I think over the last 2 years at different times we've suffered in different ways. We've touched upon the VES scheme, and there was obviously a report done on it by the NIAO, and it is I think a pretty abject lesson in how not to try and do reform. It was a clearly an austerity cost-saving scheme dressed up as reform, which has which led to money being spent, but without any real positive reform of the civil service or its capability. It is precisely as the age profile is exactly as it was. We have, however, used up a significant quota of our limited borrowing headroom through RRI in order to effectively pay for early exit, and we haven't fundamentally reformed or improved the civil service. We've simply it would be helpful to have the department acknowledge that at some stage.
It might be interesting because we had, I think, previously when the Minister was with us just before Christmas, we had some discussion about and I know it wasn't particularly about this issue, it was to do with disciplinary issues with RHI, but it was the issue of the Northern Ireland Civil Service Board, sort of the senior board. It would be interesting to note if this was ever on their risk register, or if they'd actually considered the fact that on their watch there was a voluntary exit scheme that basically didn't seem to achieve, well, we don't really know what it was trying to set out to achieve in the first place. But since we're back in this position where we particularly started, and we have heard about the age profile within the civil service, we have heard about the lack of opportunity for younger people coming into the civil service. We appreciate what the new head of the Northern Ireland Civil Service is trying to do with apprenticeship schemes and bringing people in, the rest of it. But there doesn't seem to be a lot that has actually changed. So I think it's important that we do write to them and we do seek sort of clarity on this issue fairly quickly. Are we agreed?
Chair, just before we do that, could I ask that the clerk or the staff would cross-check the claims of this letter with what the Assembly was told by the relevant minister at the time when the VES was being introduced? Because I have some sort of recollection of it being sold to us on the basis of making some transformational change. which patently did not. So I'd just like, before we write that letter, to have checked back as to what the Assembly was actually told by previous Department Minister about the value and purpose of the exit scheme.
Go ahead, Peter.
Chair, could I suggest that the committee actually writes to the department and ask them to do that, and then I'll do the same. But to ask them what they said they were going to do and what did we actually get at the other end.
Yeah.
Okay. Are we agreed?
Okay.
Great, thank you. Next item on the agenda, a consultation on the McLeod remedy. The committee was asked to note at page 292, notice of a public consultation ending on 21st of February 2022 on secondary legislation which will close the legacy principal civil service pension scheme in relation to service after the 31st of March 2022. The department advises that most public sector members had already moved to the alpha pension scheme. That's not the final salary scheme, that's the career average, yes, in 2015, or subsequently transitioned between 2015 and 2022, so they are not impacted by the planned move. The legislation is in line with the LCM that the Assembly previously approved. Is the committee content to write to the department seeking clarity on the timescales by which the McLeod remedy will be released or realised by public sector pensioners? Is the committee also content to write to the department and seek its estimate of the anticipated increase in Northern Ireland civil service / public sector retirements over the next few years, owing to an increase in final salary benefits which can be secured at age 60 rather than at state pension age? Are we agreed?
Agreed.
Agreed. Thank you. PAC report on the justice system. The committee is asked to note on page 351 a copy on the memorandum of reply from the DOJ in respect to the PAC report entitling Speeding Up the Justice System. Are we content to note the correspondence? Noted and agreed. Disability strategy. The committee is asked to note on page 359 a copy of the departmental correspondence to the Committee for Communities on the cross-department working group on a disability strategy. Is the committee content to note this correspondence? Are we agreed?
Agreed.
Agreed. Defamation Bill. The committee is asked to note on page 362 correspondence from Mr Paul Tweed providing commentary on the committee stage of the Defamation Bill. Matthew, you want to say anything?
Well, I'm flattered to have got a letter from Paul Tweed, I suppose, in which I'm the subject of his. I join illustrious company and people who've received, have been named in letters by Mr. Tweed, but I was obviously scrutinising a bill, and he dislikes what I said, but that is his right, of course.
Can you assure you, Matthew, that others in this room have had much more difficult letters from Mr. Tweed than that one? So be very thankful. It isn't,
Indeed.
a letter that has phrases like an horrendous abuse of privilege, etc. in it. So you're lucky.
Right. So, is the committee content to note this correspondence and for the clerk to contact Mr Tweed and confirm that he is content for it to be published in the committee's report? I think it's worthy that we get in contact with him and ask him that. Are we agreed? Agreed. Energy efficiency. The committee has asked to note at page 267 a report from FMB Velux on raising energy efficiency in homes. Is the committee content to note this correspondence? That's agreed. Are we thinking about the forward work programme and sort of obviously timings? A lot of the issues to do with building regulations and improvements therein. I think we might have to sit down and have a think about how we cover that, and if we got the time and capacity to cover that between now and sort of the end of the mandate, because there's quite a few of these issues that are coming through. Okay. Next item, the Brexit report. Committee is asked to note on page 390 a report from the Northern Ireland Chamber of Commerce on Brexit and its impact on local businesses. Is the committee content to note this correspondence? Agreed. Banking Forum. The committee is asked to note on page 430 a note from the Committee for the Economy and the anticipated Banking Forum. Pat, do you want to say something?
Bear with me.
Page 430.
Doesn't seem actually.
It doesn't really say much, but just obviously we're.
That's okay. No comment.
Okay. Cool. Okay. Are we agreed?
Agreed.
To note? Great. And members are asked to consider the composite request at page 481. Content that the composite request is an accurate and complete record of the committee's information request. Is this agreed? Agreed. Excellent. Forward work programme, draft forward work programme is page 449.
Mr. Chairman, just before we get to that, I wonder, we're not haven't been too long today. The Minister over the Christmas period announced a package of payments to businesses that have been affected by the latest round of curtailments, closures, etc. Now, I'm delighted that LPS will once again have an important role in that, which would strike me as mean that the payments will be timely and efficient, though they are writing to all businesses asking them to confirm that their situation is the same as it was during the localised restriction payment scheme. I wonder, could we ask to be kept up to date as a committee on the rollout of that scheme, which will be absolutely essential, particularly to the hospitality industry, to survive? And I think we've all been approached at constituency level by businesses that were depending upon the Christmas period as a lifeline to sustain them during the very dire January to March period. And I certainly over Christmas noticed half-empty restaurants and mass cancellations. So therefore, I think a lot of businesses are depending upon this scheme to be rolled out very quickly so they can balance the books as they go into a very poor trading period. I have confidence in Ian Snowden and his team to deliver the scheme, to deliver it well. I do. But I still think the public will be expecting this committee to keep a very tight eye on the rollout. And also what arrangements will be made that if MLAs have particular problems with constituents who have businesses, that the same efficient system that was evident this time last year will be tabled again, because that certainly helped an awful lot of us to deal with some quite anxious traders. I understand it's a £90 million scheme, based on the rateable value of the property in tiers of 10, 5, 10 and £15,000. Very welcome, but needs to come pretty quickly.
Is there just any other members? Has there been any indication where we haven't had the LPS not have their?
There was a statement issued by the Minister just before, a written statement.
I know it was a statement, but I mean, I think my office yesterday contacted LPS. I'm not sure.
Well, if there is a direct line contact or an email, that
there
would
was
be good.
Beforehand, wasn't there?
I haven't received it in my office, but we're closed because of the coronavirus, actually, so it may be sitting waiting for us. But I'd like a reassurance that the same timely and efficient rollout will be evident this time round, particularly given the fact that businesses are really will have no turnover worth talking about in January and February, but all the bills still have to be paid.
Okay. Thanks very much indeed. Therefore, forward work programme, page 449. Is the committee content to add a summary oral briefing on January monitoring in the meeting on the 26th of January? Yes. Great. And to remove the written departmental brief on the 12th of January, as the committee has already considered this. Are we agreed? Agreed. Members content with the forward work programme as amended? Agreed. Any other business? Good. Excellent. Date and time of next meeting in here, team, 1400 next Wednesday. Thank you very much indeed, and thank you very much indeed for our first meeting of 2022. Thank you.
Thanks, members. Thank you.
Thank you.